This is Daniel Horowitz. As a lawyer for physicians, I strongly oppose federal interference with state decisions regarding medical cannabis. For this reason, I am posting this video discussing medical marijuana law in California as it relates to medical doctors. Medical cannabis has become a vital therapeutic option for many patients in California, offering relief for various conditions within a regulated framework. By combining insights from the Medical Board of California and ethical perspectives from the AMA Journal of Ethics, this blog explores the legal framework, physician responsibilities, patient access, and ethical dilemmas surrounding medical cannabis. We sharply criticize the federal government's marijuana interference policies. First, what is the legal framework for medical cannabis? California has been a pioneer in medical cannabis legislation. The Compassionate Use Act of 1996, which was Proposition 215. This legalized cannabis for medical use with a physician's recommendation, marking a significant shift in healthcare policy. This was followed by Senate Bill 420 in 2003, which clarified guidelines for medical cannabis use and introduced identification cards. The Medicinal and Adult Use Cannabis Regulation and Safety Act of 2017 further unified the regulation of medical and recreational cannabis, ensuring safe access for patients. However, the legal landscape is complicated by federal law, where cannabis remains a Schedule I controlled substance under the Controlled Substances Act. This federal classification implies that cannabis has no accepted medical use and a high potential for abuse, creating a conflict with state laws and science. Physicians must navigate this dichotomy, as federal law technically prohibits prescribing cannabis, though recommending its use is protected under free speech, as upheld in Conant v. Walters. However, the recommendation must be separate from any act to actually facilitate the violation of federal law or the doctor risks federal interference. Gonzalez v. Raich is a Supreme Court case which you can easily find on Google. The case allowed the federal government to interfere with states' decisions on marijuana. The court decided that because Congress could regulate commerce under the Commerce Clause of the U.S. Constitution, this somehow meant that Congress could criminalize the production and use of homegrown marijuana. There is no logic to the decision. It is an invented excuse to let the federal government take power from the states. The judges pretended that growing marijuana in California can affect the price of marijuana in other states, or affect the ebb, flow, and distribution nationwide. That argument is a stretch. Let's talk about the state of California's view as to conditions which qualify for medical cannabis. In California, medical cannabis can be recommended for a broad range of conditions, including chronic pain, cancer, HIV, AIDS, epilepsy, multiple sclerosis, glaucoma, severe nausea, e.g., from chemotherapy. Any chronic or persistent condition that substantially limits major life activities as per the Americans with Disabilities Act. Physicians have flexibility to recommend cannabis for conditions they deem appropriate, provided they adhere to standard medical practices and document their decisions thoroughly. Physicians recommending medical cannabis in California must follow strict guidelines outlined by the Medical Board of California, while also grappling with ethical considerations highlighted by the AMA Journal of Ethics. To protect themselves, doctors should conduct a good faith examination. In other words, don't be a marijuana dealer, be a real doctor. Physicians must perform a comprehensive evaluation of the patient's medical history and condition, either in person or via telemedicine, ensuring the standard of care is met. Informed consent is important. Patients learn about marijuana from friends, TikTok, and Dr. Google. You should give patients real information about the benefits, risks, and potential side effects of cannabis, including drug interactions. This actually takes some work and journal review. Obviously, you cannot in any manner directly or indirectly dispense marijuana. You should discuss it with as much detachment as if you were recommended a trip to the moon. You can recommend it, but you have no ability to make it happen. The AMA Journal of Ethics underscores several ethical challenges for physicians. Since cannabis is not FDA approved, physicians may face uncertainty about its efficacy and safety due to limited clinical research, largely restricted by its Schedule I status. Recommending a substance that lacks standardized dosing or federal oversight raises questions. Additionally, physicians must balance patient autonomy with professional integrity. Some patients may seek cannabis recommendations for non-medical reasons, pressuring physicians to act as gatekeepers. The AMA Journal of Ethics notes that physicians must ensure recommendations are based on medical necessity, not patient demand, to maintain trust and avoid legal risks, such as scrutiny from the Drug Enforcement Administration. It's tough saying no, but being a real gatekeeper is the most ethical approach. Do not give any legal advice. Who knows what the law is at any given moment? You might be right by why take a chance. For example, patients may face restrictions in federal housing or workplaces, and traveling across state lines with cannabis remains illegal, as highlighted in the AMA Journal of Ethics. Patients must be educated about these limitations to make informed decisions. Keep in mind that if you recommend marijuana and the patient has an accident driving or operating machinery, while impaired, your warnings and examination may be important if you are sued or the patient's accident leads to a medical board complaint. The AMA Journal of Ethics emphasizes that patients must be informed about the lack of FDA regulation, which means cannabis products may vary in potency and quality, increasing the risk of adverse effects. In summary, your job as a physician recommending marijuana should never cross the line into advocacy, promotion, or politics. If you get into any troubling exercising your judgment as a physician, please contact me at 925-283-1863. We will advocate for you and protect your right to best advise and treat your patients.